When one party fails to honor his or her part of a contract, there is a breach of contract. A breach occurs whenever one party makes it impossible for the other party or parties to perform their obligations, does something against the intent of the contract, refuses or is unable to perform his or her obligations. Not all breaches of a contract make a contract lawsuit bound. The decision to try a case rests largely on whether or not the contract breach is material. Additionally, the courts will require that the material breach is significant to the objective A's of the contract. If these conditions are met, the injured party may be able to ignore or excuse the conflict, communicate the discrepancy to the other party, give the party an opportunity to amend the breach, withhold performance until the breach has been eradicated. When possible, complete the obligation on their own, deducting costs from any payment. Negotiate modification to the original contract terms with the guilty party. The general rule is that parties in a contract must fulfill their obligations as specified in the contract unless the parties agree to modify the contract terms, or the actions of the party who deviates from the terms of the contract are implicitly accepted, ratified, by the action or non-action of the other party. Breach of contract leaves the non-performing or improperly performing party open to a claim for damages by the other party. The non-breaching party is relieved of obligations under the contract by the other party's breach. In support of the claim, the aggrieved party should have worked to fulfill his or her contracted obligations up until the breach occurred. In addition, the aggrieved party must have done nothing to make it unreasonably difficult for the other party to perform his or her obligations. The doctrine of substantial performance saves a party who has largely fulfilled his obligations under a contract from suffering major loss merely because he has unintentionally fallen short in some particular way, which does not affect the essence of the contract. Remember that if a cure period notice is not sent out, then there is not a real breach pending yet. It must be sent to the non-performing agent and also to the title company. What if it is the title or escrow company who did not send over to the buyer the required information on the HOA? The title company is not a party to the contract, and the title officer should not be inserted in the contract under the title company information. The email of the title officer and the title company address and phone number should be completed. You could cure the seller for not having those sent on time and send a copy to the title company also. If the listing agent sent a cure to the buyer's lender and not the buyer's agent, the cure period notice would not be valid. Because neither the buyer nor the buyer's agent received a copy of the cure notice, the buyer has not been given a valid cure notice. The listing agent should immediately provide a cure notice to the buyer's agent. Remember to be careful with your client's money when writing addenda, so that if it is of no fault of their own, they will be able to receive their earnest money back. Take a look at this scenario. The buyer and the seller entered into a purchase and sale agreement through which the buyer made a $1,000 earnest money deposit. There was a problem that needed to be addressed with the lender of the buyer and therefore needed extra time to close. The buyer and the seller agreed to the following language in an addendum to their contract. Buyer to deposit $5,000 additional earnest money into escrow to be applicable to the purchase price and released to the seller. The buyer was unable to obtain a loan. Therefore, the title company released the initial $1,000 earnest money to the buyer and the $5,000 to the seller. I am sure the buyer did not want to just give money to the seller and thought that his loan would be approved. Make sure what you write is what the intent is, and also protect your client's pocketbook.